For judgment, item number 1.
Under the aforesaid facts and circumstances and the discussions made, we are of the view that the conviction is liable to be made under section 304 part 2 of the IPC, which is accordingly done. Aforesaid section prescribes the penalty of rigorous imprisonment, which may extend to 10 years. The records reveal that the appellant was arrested on 2/11/16. Though the aspect as to whether he was on bail during the trial is not clear, impugned judgment is of 28/8/2018, and therefore even from the date of the judgment, the appellant is in jail for a period of more than 6 years. Consequently, the sentence is altered to rigorous imprisonment for the period undergone with a fine of rupees so and so. The appeal is accordingly disposed of.
Right.
We have recorded our appreciation for the learned amicus.
Your Lordship, I would like to mention few unlisted matters, Your Lordship. We had done a filing yesterday, Your Lordship. We are praying if may be taken up today, Your Lordship.
Today,
Yes, Your Lordship.
matter regarding,
It's a CRP, Your Lordship.
what is the urgency?
Your Lordship, the execution proceedings have been initiated. So one of the matters execution is listed on the next week, Your Lordship. There are 6 numbers of CRPs, Your Lordship, but they are having the same question of law, single question of law.
Where is the urgency? We don't find the urgency. Have we done Monday? We don't mind having today, but if there is no urgency, why should we entertain? What is the problem on Monday?
Your Lordship, the conducting council.
That's not too much of a concern for us.
All right, Your Lordship.
Concern is the urgency of the matter.
All right,
If you are mentioned, you have to be there. Monday.
all right, Your Lordship. All right.
Motion, item number 1.
Lordship, this is a matter pertaining to refusal to entertain the candidature of the petitioner as a professor in the Department of Pharmacy under REPANS. Lordship, the petitioner had joined his service initially as senior lecturer under REPANS in the year 2003. And thereafter,
Just a minute, Mr. Gautam. What is the stage now?
Your Lordship, I received notice on behalf of the respondent.
What is the stage of the recruitment process?
I have to take instruction, my lord.
No, because this started a long time back and he was initially found ineligible in June 2024 and the ministry letter is of October 2024.
Yes.
We are in December. What is the, do you know what is the stage?
nothing has been done as yet. And what we have stated in the petition is that the interview is going to be held in the near future. It has not been held. And as per the information received by the petitioner,
We'll issue notice.
Yes, my lord. And in the meantime, Lordship, by looking at Annexing 19, the last page,
Yes.
page 117,
Yes.
I think Ministry of Health and Family Welfare will also be necessary party. It is the ministry who rejected his
Not
presentation.
been made a party.
Yes, not being made a party.
Lordship, ministry is part and parcel of the REPANS.
No, ministry, the matter was referred to the ministry.
Lordship,
Since you are reviewing the letter of 16/10/2024 of the ministry, I think ministry needs to be made a party. That's not very difficult for you. I think you can file an application, will you immediately allow it?
Lordship, may I take a Lordship to page 31?
Then why don't you do one thing? If you file an application on Monday morning, we can have this one Monday.
All right, no problem.
And, because otherwise issue notice again, implement application again in notice, okay? We'll have this on Monday.
Before that, the Lordship, may I take a Lordship to page 31?
31 is,
The composition of the Board of Governors. Here, Union Minister of Health and Family Welfare, Government of India, is the president of the board. So, the board means board of the REPANS. When REPANS is implemented as a party, so all these authorities are included.
he becomes a chairman de facto by his office, ex officio. Ministry is a different. You have also impugned the order of the ministry 1610. Can you see that order? Who has passed the order? Is it by REPANS or is it by the ministry?
Lordship, you're even in the process of...
Why are you on a technical issue? Implement it. It's not going to cause any harm. Monday we'll have it. Monday or Tuesday, whenever you want.
We'll file the amendment.
Small I, a very formal I for implement. You love it.
It may come on Wednesday,
Wednesday will be a DB.
whether Thursday possible, my lord, because I have one matter in principal bench. Monday, Tuesday, if possible, Thursday.
Thursday, can you wait till Thursday?
Depending upon my lord, there is some urgency in the matter because if the interview is held.
No, we are not going to see, we are not very inclined to pass a blanket order of stay. We would say whatever is done will be subject to the outcome, and if you are successful tomorrow, your candidature has to be taken into consideration. Because
There's only one post in All Sec.
no, understood. If they are, in the meantime, they go ahead and appoint somebody else, considering you, and tomorrow we find you to be eligible, then it has to be redone.
And
Give them much of protection.
there is only one eligible
But we will not
candidate.
stop the recruitment. This is an important post. It cannot go vacant. It cannot lie vacant for a long time. But we'll protect your interest. Don't worry about that aspect.
Not, sir, we can file our application by today itself. And if the matter can be listed by Monday, with his convenience.
Monday you can have your colleagues see.
Yes, yes, my lord. My
But
colleague
if the
can,
order tentatively he has said what we are going to pass.
no problem.
Your colleague can be there.
Yes, yes.
But try to file it early in the morning on Monday and bring it to the court. We can have it as the last item on Monday. Okay. We, students of Learned Council for the respondents 1 and 2 at the outset has pointed out that an order dated 16/10/2024 passed by the Ministry of Students Protection is one of the subject matter of challenge. The aforesaid ministry has not been arrayed as a party respondent. Ms. Students of Learned City Council for the petitioner at this stage raised for some time to file an application for implementing the ministry. Since urgency has been expressed, let such application be filed by Monday and the matter be listed on that date for motion.
That's okay. Item number 2 for admission.
My lord, this is a contempt petition filed for non-compliance of this honorable court order.
What about the respondent number 11?
My lord, the address has been given very clear, and earlier the notice were issued, and every time it has come back. But now this time I don't know what is the reason.
If it would been some other matter, we would have proceeded. It's a contempt matter. Penal consequences are there.
My lord,
So aspect of notice is very important.
my lord,
See you are taking steps on 5/9/2024.
my lord.
So cannot go for a presumption. You can at best ask the registry to do a tracking and put a note on it.
My lord.
Okay, since neither the AD card nor answer notice has come back. Service report upon the respondent of 11 is awaited. Postal. Office note, the last office note dated 5/12/2024 reflects that neither AD card nor unserved notice has returned back. It appears that steps were taken for service of notice upon the said respondent number 11 on 5/9/2024. Office is directed to undertake a tracking of the notices issued by registered postal with AD and make a report after a week.
Obliged.
Item number 3.
My lord, I am appearing on behalf of the respondent number 6, and the amount of rupees 20,70,732 will be disbursed to the petitioner by next week.
You are supposed to have the instructions from the Deputy Commissioner.
Yes, my lord, I have
You
obtained.
have had the instructions.
Yes, my lord.
Perused the last order dated 7/11/2024, by which Ms. Susan Learned Council for the respondent 6 was granted time to obtain instructions from the concerned Deputy Commissioner regarding compliance of the order of this court. Para, Ms. Learned Counsel has informed that an amount of rupees
20 lakhs 70,732.
20,70,732 is ready and will be disbursed to the petitioner within a week.
Yes, ma'am.
In view of the aforesaid submission, matter is adjourned to be listed immediately listed after the winter vacation. On this date, the further developments will be appraised.
With your lordship's permission, your lordship, the matter may be taken up next week on Friday. The reason being is that this amount has been lying with them since June of 2024.
Will it be possible next Friday? Next Friday it may not be possible. Friday is the last working day.
Thursday,
Let them pay. We are monitoring the matter. We have recorded a statement.
Yes, your lordship.
We'll have it immediately after the vacation.
Deeply obliged. Item number 4.
May it please your lordships. My lords, today the main petition is listed along with the IA. My lords, the private respondents, all of them have been served. 3 of the respondent numbers, 11, 16 and 25. My lords, for this, my lords, I had checked with the registry. My lords, from their report, my lords, details are not found. This is what they're getting. But I've gone to the postal office myself. My lords, I have the tracking reports of them. My lords, it's being delivered as per.
You put it on record, file a small affidavit.
My lords.
Record will pass an order regarding completion of service.
Yes, my lords.
Research and Learned Counsel for the petitioner has submitted that despite the office note dated 5/12/2024 regarding the lack of confirmation of service of notice upon respond numbers 11, 16 and 25.
Yes.
He has collected certain information, including track record from the postal department, and submits that the notices have been served. Let an affidavit be filed in this regard by annexing the track report.
My lords, secondly, insofar as the IA, my lords, though it concerns only respondents 1 and 2, because I'm seeking for calling of records. My lords, this honorable court had also sought for service of notice upon the private respondents. My lords, the AD card has not come back for most of them. But, my lords, as per the office report, my lords, the respondents are saying they've received in the main, which will
So if you find it in the main case, we'll perhaps admit for the, except for the other IAOs.
my lords.
You just point, you remind the court.
Yes, my lords. Wait for it.
Item number 5.
Lords, in item 5,
You have filed the affidavit, madam?
Yes, Your Lordship.
Yes.
my lords, I'm seeking time for filing rejoinder.
File rejoinder, he spoke. Office note dated 14/11/2024 reflects that the state respondent has filed the affidavit. Para, Research and Learned Counsel for the petitioner prays for and is granted 3 weeks time to file rejoinder affidavit.
Objection.
Item number 6.
Your Lordship, on behalf of the state respondents, we have received verbal instructions that the governor has decided to constitute a study team to look into the salary component and also the service rules of all the autonomous district councils. Therefore, the paradise comments were pulled back and there will be new additions to the same. Therefore, time will be granted, Your Lordship, to find the affidavit.
I have instructions to appear on behalf of the respondents 1, 2 and 3.
Okay. Would you like to say something in this matter? File affidavit. Yes. Okay. Ms. You are the state council.
Yes, Your Lordship.
By the state council. has submitted that there are certain developments towards redressal of the matter, and the same would be put on record by way of an affidavit, for which she prays for some time. Pursuant to London City Council submits that he has been instructed to appear on behalf of the respondents 1, 2, and 3, and would also find necessary affidavit in opposition. And you are assisted by whom? Long distance assistance. Okay, that's the best way. List up to the winter vacation to enable filing of affidavits.
Your Lordship, in the meantime, the status quo maintained earlier by the
The order of status quo passed earlier is extended till the next date of listing.
Obliged.
What is item number 7?
Well, in this case, if Your Lordship may kindly allow us some more time to pay the remaining amount of 8 lakhs. Out of the decretal amount of 18 lakhs, we have paid 10 lakhs. But yes, and another 8 lakhs is remaining. So my client is facing hardship these days.
This was the submission on the last provision also.
Yes, my lord.
We can wait, my Lord.
What is the response?
I have no objection.
Well, my lord, in fact, my humble
It's
praise.
very considerate,
My lord,
sympathetic to your client.
my lord, this case, I think in this case may go to the civil court for execution. My lord. This court has been used as an executive court. My lord.
Okay. On the prayer of pursuant to learned counsel for the appellant, further time of 3 weeks.
After vacation, my lord.
3 weeks will mean after vacation also. Further time of 3 weeks is granted to enable clearing of the dues to the respondent numbers 1 and 2.
No, it's only upon the
Respondent number 1.
respondent number.
Respondent. Oh, 8 lakhs is due. Yes. Upon the respondent. List up to the winter vacation.
Well, obliged.
This time you make the payment.
My lord, we'll try that.
Item number 8.
Yes.
Yes, my lord, this matter is listed for the first time. This is an application of the Section 5 of the Limitation Act for continuation of a delay of 335 days in filing for an appeal.
Appeal against what? Appeal against?
Pardon, my lord?
Appeal against what?
Appeal against declaratory suit. Appeal against judgment and order dated 4/10/2023.
What were you in the suit? What was your position in the suit?
My lord, I was a plaintiff. However, the learned senior civil judge have declared that the defendant is the owner of the LSC.
Your suit has been rejected, dismissed.
Yes, my lord.
Come against dismissal of the suit.
Yes, my lord.
Why is the delay? It is your suit.
Actually, my lord, prior to handling of the brief to me, 2 advocates were engaged. However, the first advocate was additional government advocate. So the brief was handed again to Mr. Jaishner Ramding Moya. Then he appeared for examination for grade 1 Mizoram Judicial Service. So before he could file the appeal, he is qualified for examination of mains exam. So the brief was then again handed to me on 21st of October.
Did you clear the examination?
Result is awaited, my lord.
Where have you stated all this? Paragraph 3.
My lord, if I take my lord to page 33 and 34, acknowledgement letter is signed.
For the applicant who by means of this application filed under section 5 of the Limitation Act has paid for condonation of delay of 335 days. He is referring the appeal against the judgment and order dated so-and-so, passed by so-and-so, in declarative suit number so-and-so. That notice be issued. Yes, madam, we'll be taking for 2, 3 and 4. No, 2, 3 and 4. 2, 3 and 4.
2, 3 and 4.
Ms. Swanson and the State Council accepts notice on behalf of respondents 2, 3 and 4. Let extra copies of the application be served upon her within 2 days. Let steps be taken for service of notice upon the respondent number 1 by registered postal TD. Steps within 2 days. List of proceedings along with service report.
Okay, madam.
For hearing item number 9.
My lord, it appears that the counsel for the appellant is not present. Oh.
Same counsel is in the other case also.
Yes, my lord. In item number 10.
Right there, very ominous. No hearing, even today. You want to take his place? No, my lord. We thought that you had volunteered to take his place. You are most welcome otherwise. If you want, we can give you the fourth brief. But I'm not sure if it is a jail appeal or what. So that appeal is an arbitrary.
This is an hour. I've talked to the appellant.
Better to stay away. Yes.
I've talked to the appellant counsel last night and I thought we were going to have a hearing. I'm appealing for the state respondents in this matter.
Yes, what did you say?
And I thought we were going to have a hearing today, but I don't know. They have not shown up. Oh,
Yes, come.
he's here.
Please come, the court is waiting for you. You are almost to be replaced by your colleague.
My apology, my lord.
We did not allow your replacement.
My lord, I got stuck in the traffic jam. Station I'm ready, my lord. I'm ready.
Yes. Your brief is not there.
My lord, my file is on the way, my lord. My junior will come within seconds, my lord.
You come in a wagon or what? Wagon is following you. Which train?
My lord, two items which are fixed for hearing are my case, my lord. So,
take it in, man. Don't hurry up.
My lords, if I just may make one mention, my lords.
Yes.
My lords, regarding item 4, my lords, that IA, my lords, in the meanwhile, if the tracking report can also be called, my lords, because it might suffer because of some technicality. Item 4, my lords, IA. My lords, the service of notice of the private respondents.
What was the order last?
My lords, in the main petition, your lordships had said that I may file an affidavit of the 3 respondents who I said the notice has been served on.
Yes.
I.e., my lords, the same respondents, but my lords, the tracking report may be called because 3 or 4 respondents.
If they are served in the main petition, may not be too much bother with the idea.
Yes, my lords, but 3, 4 respondents are there, my lords, who are not in the main petition. I mean, they are.
Okay, in the item number 4, other than IA also 49, okay? Since the aspect of service upon the respondents is not clear from the registry to furnish a tracking report from the postal department.
Extremely written.
There's no only one other is a petition, that will be separate.
No, may I please look at it? My lord, the present appeal is the first appeal arising out of the Imperial Judgment and Order. The Imperial Judgment and Order was passed in Civil Suit number 97 of 2012. Well, 97 of 2012.
There are two appellants.
Two appellants.
Two appellants,
But my lord, here
you are the plaintiff.
I am the plaintiff.
Your suit has been dismissed.
Yes, my lord.
And suit was for? Suit was for?
My lord,
Suit was for, filed for what?
suit was filed for a declaration.
Declaration.
Yes, my lord.
Declaration of right to claims raised.
A declaration to for cancelling and declaring the cancellation order against my land pass to be null and void, my lord. The government authority had cancelled
You
my.
have challenged a cancellation order.
Yes, my lord. The cancellation. I am challenging the cancellation order of the land settlement certificate.
Land allotment certificate.
My lord.
That was cancelled. You had come before the court challenging the cancellation.
My lord.
And who are the defendants?
And the defendants, and the defendant number 1 to 6 are the state defendants.
Okay.
And the defendant number 7 to 21 are the private defendants.
Okay.
Well, and my lord, here, the facts of the case is that in the year 1989, when the Mizo National Front volunteers returned from the insurgency movement, and they are without landless, they are without any landed property, and they were to be, as per the decision of the government, they are to be allotted house sites. And the Revenue Department looked for vacant land in one area is all called Loipu, in Loipu area. And here, my lord, the survey was done, and the preparation of house site plan for 234 house sites was completed for allotment to the landless MNF returnees.
You were one of those, you too.
Actually, no, my lord. Subsequently, the story goes on, my lord. After the MNF returnees are about to allot land, they do not want that portion of land to be allotted because they want to be accommodated at Mau Mall area. So accommodation was given to that Mau Mall area by shifting the accommodation from that Loipu to Mau Mall. Meaning that Loipu became a vacant land, my lord. And after that Loipu area became a vacant land, the government again made a decision to allot those vacant land to landless persons, my lord. Those who are not having land, they are to be allotted house sites. Then I am one of those landless persons, my lord, who are allotted land by the government authority.
Yes. You were the beneficiary of the decision,
My lord,
both of you.
my lord.
You were landless.
Oh, no, yes, including including some persons which I represented before the trial court. And after that, the survey was done and the house site plan was prepared, and the house site plan was approved by the government in Mizoram, and the approval was communicated to the government authority. And house sites were allotted to 35 landless persons. 35 landless persons.
Among these 35, you two are also there.
Yes, my lord.
Yes.
And my lord, after that, we had collected the house passes, and we have also paid the necessary fees. All these were done after completion of all the caudal formalities required by the government. And the conversion of that house pass into land settlement certificate was also done, my lord. After conducting proper verification and demarcation.
Okay.
And after that, my house pass was converted into permanent land settlement certificate. And
Yes.
here, my lord, I would like to, in this connection, here, the decision of the government was also published in the government gazette.
Okay.
For allotment of land to the landless persons at Loipu Village Council area. Here, after we are allotted land to us, then there was a application made by the respondent number 7. Respondent number 7 is Mr. Shabdela, H. Shabdela, saying that he is having periodic patta, one land pass, periodic patta number 159 of 1981, within that portion of land where we were allotted LSC's allotment, saying that the allotment had overlapped his periodic patta.
Yes.
And after that, the Revenue Authority tried to settle the matter, and summons were issued to the respondent number 7, but he did not appear. So, after he fails to appear, then decision was made by the concerned territory of the Revenue Authority to issue show cause to respondent number 7.
So, regarding what?
So cause regarding us to buy his periodic patta shall not be cancelled.
Yes.
You have made it the show cause, my lord,
Yes.
which is at page 23 of the paper book.
23.
23.
Yes.
This is the show cause letter issued by the Assistant Director of Land Revenue Settlement. To Mr. Swenso, subject show cause notice. Sir, regarding your land, which is measured by Sri Swenso, surveyor bearing periodic patta number 159 of 1981, measuring 8 bighas, we request you to clarify the area of your land 3 times, and you do not appear. As such, along with the surveyor who measured your land, the remaining land other than this measurement is included in Loipu House Site Plan, revised by the government. To have an appropriate plot, additional 11 bighas was allotted to you. The house site plan is processed by the government, and house pass allotment is issued to persons who do not possess any plot of land. Unfortunately, while the plan process is in progress, Sri P. Zatwala, surveyor, remeasured your land, which is 8 bigas to 24.30 bigas, which resulted in overlapping Loipu House site plan plots. The LSC conversion, which was issued to 15 of your relatives, including you, obstructed the process of the government action at Loipu. Apart from your land, 8 bigas, additional 16.30 bigas, which was added to your land by the surveyor, is in contrary to Department Office Circular by number so point number 22, as it is possessed without any technical clearance. The overlapping resulted due to not acknowledging Loipu Village Council. It was measured using the signature bearing map of BCP. Therefore, you are informed to circles as to why your LSC and other 15 LSCs which you made in the name of Sri so shall not be cancelled within 7 days from the date of issuance of this letter. If you do not make any clarifications within the said period, you will be regarded as having no reasonable ground of clarification, and you will not be allowed to protest the process of the department at the later stage. So this is the supposed letter, my lord. And my lord, here, in order to clarify the exact situation, as stated by the government concerned, my lord, here at page 21, the general report and the statement of Loipu House site plan is prepared by the assistant director. Page 21. This is the general report, my lord. If I may read, my lord. Due to complaint made by Sri Sabbela and Sri Chongkima, report is made by the government in this behalf regarding Loipu House site plan. This report is made to solve the dispute easily by the concerned authority. Number one, the eminent returnees had 234 numbers of house site plan plots surveyed in the year 1989 at Loipu near the land allotted to soil department. In this site, Sri Sabbela periodic pata number so-and-so and Sri Si Chongkima periodic pata number so-and-so had a plot of land, and therefore they made a request to exclude their land from the plan. As such, the house site plan was not processed. Therefore, house site plan was made at Mount Null in favor of the returnees. Number two, as per the government letter number so 26/2004, the house site plan was to be surveyed again. In 16 August 2004, a meeting was held by Loipu VC Lamuit Sri William Zinga, Deputy Director of Survey, to make a plan other than Sri H. Sabbela and Sri C. Chongkim's land. In this meeting, a resolution was made to investigate the plan which was discarded. Sri C. Chongkima and Sri H. Sabbela were called many times to prevent overlapping of their land while making the plan, but they did not appear, and so their land was measured and was excluded from the plan. As Sri Chongkima made an application to convert his periodic pata into house site plan, Sri Joshua, a surveyor, was allotted by the Revenue District Office to take measurement. After taking the measurement, it was excluded from the house site plan plot, and so the house site plan was processed after excluding Sri Chongkima and Sri H. Sabbela's land. While processing the house site plan, Sri Tanpara Ramano, who is the landholder of LSC so and Srimati Tansani Chilwen, who is the holder of LSC so submitted the house site plan objection. The complaint was further investigated with them. The LSC cover area was within the measuring land of Sri C. Chongkima's house site class, and therefore house site plan continued to be processed. The house site plan was later approved by the government on 6 January 2006. The land was allotted to 35 persons, and accordingly, house site was issued. After careful survey and development, Sri Chongkima and Sri H. Sabbela made a complaint again. Pulang Monkima surveyor investigated Sri Sabbela's land and reported that his periodic pata was converted to house site plan plot number 1 to 16 and house site plan plot number 14 to 35 is overlapped. Soon, Sri H. Sabbela's conversion process was checked, and it was found out that Sri so-and-so surveyor Revenue District Office measured Sri Sabbela's periodic pata, which is 8 biga to 24.30 bigas. Other than 8 biga of the periodic pata, the remaining 16.30 bigas is in contradiction with the department's office circular so, as it was processed without taking technical clearance and was signed by Mabok Village Council President without the acknowledgement of Loipu Village Council President, VC, and therefore it resulted in overlapping. As per Loipu VCP letter and VC direction copy, other than the Pedic Pata 8 bigas, the remaining land was allotted to house site plan plot allottees. As such, the dispute arises. After issuing house pass from the house site plan, Sri C. Chongtengkung made a complaint, stating that his land which is measured is incomplete. From the above circumstances, a report is made to the appropriate authority to help in making decisions. Well, what transpires is that the respondent number 7, when converting his Pedic Pata into house pass, he did not obtain any technical clearance from the concerned authority.
Why don't we do one thing? Let us read the impugned judgment. Everything will be clear. Let us read the impugned judgment.
Well,
Where is it?
the impugned judgment is
Two four-
249.
249. With that, I think that everything will be okay, clear.
My lord, the initial portion of the impugned judgment order is the submissions made by both the parties. And the decisions of issues is starting from page 263, my lord. And
263.
263, page 263, my lord.
Yeah.
And my lord, it may be also clear to read the stand taken by both the parties, which is reflected in the impugned judgment order also.
That is what we want to read.
My lord.
Read the impugned judgment. Everything will be clear.
My lord. My lord, if I may start from the issues framed, which is,
Read it from the first. Everything will be clear. 250.
my lord, from the judgment, my lord. This is a civil suit instituted by the plaintiff, Lado Mason of Lillian and Sandam Artsomoy, board resident of Lloyd, who is all against the state of Mizoram, through the chief secretary to the government of Mizoram, and 20 others for revoking or to set aside the cancellation order of the plaintiff's LSCs and for upholding the said LSCs and also for cancelling and declaring null and void of the defendant's LSCs. The defendant submitted their written statement contended that defendant number 1 to 6 had mistakenly allotted lands to the plaintiffs by overlapping the defendant's lands covered under Pedic Pata number so, which was covered into 25 numbers of house passes in the year 2005. And the same were converted to LSC in the year 2005 and 2006, and the plaintiff's LSCs were cancelled when the Revenue Authority had found out the truth and thus praised to dismiss the suit. The following issues were framed on 3/5/2016, whether the suit is maintainable in its present form and style, whether the plaintiff have cause of action or not. Number 3, whether the LSCs issued in the name of the plaintiffs and the persons whom they are representing, this is LLC number in the name of Loren Ruata, LSC number so-and-so in the name of Tanglin Kapa, LSC so-and-so in the name of Loremoy Bante, LSC number so-and-so in the name of Ram Kiangi, LSC number so-and-so in the name of Plan Chumi, LSC number so-and-so in the name of Blood Sana, LSC number so-and-so in the name of Blood Duoma, LSC number so-and-so in the name of Lorin Tuama, LSC number so-and-so in the name of H.L. Shid Puya, LSC in the name of H.L. Remruata.
This you can skip.
My lord. My lord. Whether the defendants' LSCs are valid or not, whether the plaintiffs are entitled to the relief claim if so to what extent, whether the plaintiff have lucas right to file the instant suit or any cause of action in their favor and against the defendants, whether the plaintiff can sue in favor of interested persons mentioned in para number 1 of the plaint under order 1, rule 8 of CPC, without prior permission of the court, whether the suit is bad for non-joiner of necessary parties, whether the suit is liable to be dismissed for want of sufficient court fees. The plaintiffs produced 4 witnesses, including themselves, Mr. So-and-so,
Yes.
this is,
No, but all said and done, when the government has taken a stand that the allotment to you was made by mistake, to overcome that, the burden which will be upon you would be a very high burden. See, if the government has allotted the land, government realizes its mistake, says in the court that it was a mistake, then can you say that it was not a mistake?
it was stated that the LSC issued in my favor was issued after observing all the court formalities, madam.
So that was subsequently, they have stated, stand taken in the suit as a defendant, that it was done out of mistake.
But in
They
the,
are the decision-making authority to allot or not to allot. And after allotment, when the issue came up, that it was allotted by overlapping, and they said that yes, there was a mistake, we had overlapped the periodic patta land of the defendants.
but my lord, in that regard, there were no witnesses produced before the court to produce evidence by the state authority, my lord. In order to establish that stand, also, no witnesses were produced before the trial court. So, only one witness was produced by the private defendants. And in the regard also, with regard to the validity of the Bidit Pata, the defendant witness in his cross-examination also stated that he did not pay any land revenue tax from the year 1991 to 1993. So that infers that his Bidit Pata was already expired.
So what is the limitation? Is there any limitation that if you do not pay the land revenue for 3 years, your patta gets cancelled?
Yes, during the relevant period of this period, but the prevailing, as per the prevailing act, Land Revenue Act, the periodic patta is valid for a period of 5 years. 5 years. That is also written in the body of the periodic patta also. So, what can be seen is that
Now, what would be the consequence of non-payment of the revenue?
the non-payment of the revenue
Will it
tax.
amount to automatic cancellation of the patta? Or are you still required to follow a procedure that you have not paid the revenue, we are going to cancel your patta? What do you have to say? That cannot be cancelled automatically. It's not an automatic thing. You cannot take away a right without giving a show cause.
My lord, here, as per the prevailing law, prevailing act, here, Mizo District Agricultural Land Act 1963 said that the patta holder shall have heritable
Heritable and transferable right.
but this is not periodic, my lord, here. Here, my lord, as per the registration, here, this is, I'm reading from the Mizo Agricultural Land Rules 1971, my lord. Mizo Agricultural Land Rules 1971. It's available in the Land Aqua and Forest Laws Mizoram. This is compiled next.
We're trying to have that book. We're trying to have that book from library. Okay, you can proceed with the facts.
Malam. Malam, in the regard, if I can go back to the impingement order.
Yes, it's 251.
251, Malam. Yes.
The plaintiffs produced
Plaintiff produced 4 witnesses, including themselves. Mr. Aldo Omar, the plaintiff number 1 examination in chief, deposed that they have filed a suit on behalf of themselves and on behalf of Mr. So-and-so, by virtue of permission granted under Order 1, Rule 8 of CPC, to file the suit in their name. In the year 1989, when the landless and returnees were to be allotted house site for their accommodation, the Revenue Department looked for vacant land at Loipu near the land belonging to SWA Department. Government of Mizoram surveyed and prepared the house site plan for 134 house sites. As the MNF returnees didn't want the location Loipu and they wanted to be accommodated at Mount Wall was selected for Mount Wall. The proposed allotment was cancelled. As per the wishes of the MNF returnees, Mount Wall was selected for accommodating them. As the land was lying vacant at Loipu, as per the record maintained by the Revenue Department, in the month of August 2004, the then Deputy Director, Survey Mr. William Zing and his staff went to the site at Loipu and prepared the house site plan in order to allot the vacant land to the landless Mizo tribes of Aizo. As the land to be earmarked for allotment to the landless Mizos was located adjacent to the land of Mr. Sichong Tankum and Mr. Isabella, covered by their respective periodic pata. When the house site plan was prepared, all the plots were located outside the area and boundary restrictions mentioned in their respective pipata. The portions of the land which was allotted to them were not developed by anyone and was covered by trees and plants. While making the survey, the basis of Loipu village helped the surveyors in clearing the jungle. After the survey was done and house site plan was prepared, said house site was approved by the government of Mizoram and the approval was communicated to defendant number 3, White Letter so-and-so, dated 6 January 2006. After approval of received from the government of Mizoram, house site was allotted to 35 landless Mizos, namely from serial number 5 to 1 to 35. Amongst the 35 persons, themselves and the persons whom they are representing were also included. They collected the house passes by paying necessary fees. After the house pass was issued, they approached the revenue authorities for converting the house site pass in the land settlement certificate. After conducting proper verification and demarcation, the said house site passes were converted into a land settlement certificate. The LSC issued in their names are LSC number so-and-so, in the name of Lorem Rota, son of so-and-so, LSC in the name of Mr. So-and-so. Here it runs Malok. So if I can skip. As per the notification so-and-so, 13 September 2001, published in the Mizoram Gazette, Extraordinary Volume 30, Aizo, Wednesday, 3/10/2001, number 219, Loipu Village Council was formed and the area was also defined in the said notification. The land allotted to them falls within the Loipu Village Council area. Hence, the Village Council of the Loipu Village had given clearance for allotment of the said plots to them as it was not covered by any passes pata of any persons. The revenue authorities issued a number of times to the defendant number 7 to come to the spot at the time of demarcation of the land for the house site around the land covered by Pipata number 159 of 1981. But he failed to appear and the surveyor, Mr. Zhao Shang, conducted the demarcation of the land around the land of the said defendant number 7 and left the area of 11 bighas of land in favor of the defendant number 7. Even though the area covered under Pipata number 159 of 1981 was only 8 bighas. Hence, the government of Mizoram rightly met the house site plan and also issued LSCs to them. The defendant number 7 submitted an application dated 19/8/2004 to the Revenue Minister of Mizoram for conversion of the land covered under periodic pata to house site, and the Revenue Minister had made an endorsement on application for processing the same on 23/8/2004. As the area covered by periodic pata was only 8 bighas, the revenue authorities were sure that the area of land allotted would fall outside the area of the land covered by the said periodic pata. they came to know that defendant number 7, knowing fully well that Loipur Village Council was formed in the year 2001 without routing through the Village Council authorities of Loipur, he had routed through the Village Council Mabok. It is clear from the notification referred above that the land falling within the area of Village Council Loipur cannot be verified by the Mabok Village Council authorities. Further, aside from the CP Patta 159 of 1981 was done without obtaining technical sanction. Hence, said conversion of the said period Patta into house site and to LSCs were illegal and against the norms and circulars of the Revenue Department. When the revenue authorities realized the mistake committed by them, the then Assistant Director, Land Revenue and Settlement, Aizol, Mizoram issued some cause notice to the said defendant number 7, by number so Aizol 10 October 2007, as to why the LSCs made over the land access of the area of this period Patta put in the names of so and so should not be considered. Mr. Domkim, Assistant Director, Survey also clearly mentioned in his report that the reason for overlapping of the land of the defendant number 7 and his relatives and their lands was due to the addition of 16.30 bigas over and above the 8 bigas mentioned in Pipata, and he clearly mentioned that the action of adding additional 16.30 bigas in favor of the said 8 sub-bela was in violation of the circular issued by number so. Further in his report, he has clearly mentioned that the house site passes LSCs in favor of the defendant number 7 and his relatives' name mentioned above as the defendant number 8 to 21 were made without the knowledge of the Loipur Village Council, and he submitted his report for decision of the higher authorities. Instead of cancelling the said passes, LSCs issued in favor of the defendant number 7 and the defendant number 8 to 21, the defendant number 3 proposed cancellation of LSCs issued in favor of us by letter number so and so, dated 3 January 2021. And in pursuance of the illegal proposal, the Undersecretary to the Government of Mizoram, Revenue Department conveyed the approval of the government for cancellation of the 15 LSCs issued overlapping the demarcated area of the defendant number 7. On receipt of the said approval from the Undersecretary to the Government of Mizoram, the defendant number 4 had issued a show cause notice to the White Memo number so and so, dated 6/2010. On receipt of the said show cause notice, they submitted reply to show cause notice, but without taking into consideration of the reply submitted by them, the then defendant number 3 issued the cancellation order of his order number so and so, 9/3/2012. The action of the defendant number 3 is arbitrary and biased. Although the show cause was issued to them on 6/2012, the revenue authorities had made the endorsement of cancellation of their LSCs much before the show cause notice was issued to them. This shows clearly that the revenue authorities had acted in biased manner to help defendant number 7. The endorsement of cancellation of the body of the LSCs belonging to them kept in the Revenue Department came to light when Mr. H. Ranwata went to the Revenue Department on 7/10/2010 to mutate the said plot of land covered under LSC number so and so in the name of Mr. Ramlin Liana, son of Thampuma. After he informed the other plaintiffs, and on the inquiry, they came to know that there were endorsement of cancellation made on the body of their LSCs kept by the Revenue Department. Though the endorsement of cancellation was made on the body of their LSCs kept in the office, the same was not communicated to them. When they came to know that some of the officers of the Revenue Department have clandestinely made the endorsement of the cancellation on the body of their LSCs kept in the Revenue Office, they approached the then defendant number 4, Mr. Ruzwala. He told them that it was wrongly recorded in their LSCs and he would make necessary correction in the LSCs kept in the custody of the Revenue Department. Instead of making necessary correction in the LSCs kept by the revenue authorities, the defendant number 3 issued the cancellation order mentioned above. It is clear that the revenue authorities had taken action of cancellation much before the show cause notice was issued to them. The defendant number 7 had decided to cancel their LSCs much before obtaining the approval from the government of Mizoram, as well as giving show cause notice to them. When they approached the revenue officers, after knowing the endorsement of cancellation of their LSCs were made much before the director, LRNS, Mizoram had sent proposal for cancellation of their LSCs. They were made to understand that the action was wrong in the light of so-called notice issued to the said defendant number 7 and 8 to 21. Overlapping their LSCs should not be cancelled, while the landless Mizos were expecting favorable orders from the revenue authorities. To their utter surprise, they received orders cancelling the LSCs on the ground that the land covered by the LSCs overlapped the LSCs of the said defendant number 7 to 21 mentioned above. They named Iladuo Manuel Santama had already constructed their houses and living within the said land legally allotted to them. Further, he stated that all of them, including the persons whom they are representing, had taken possession of the land allotted to them by the government as soon as the passes were allotted to them, and all of them are looking after the said lands. The action of the government of Mizoram and defendant number 2 are illegal, arbitrary, biased, and against the law in Mizoram. He pointed out that the names of Mr. Lalmingsana, Mr. Swenso are wrongly mentioned in the cancellation order. In fact, the LSCs is issued in the name of Mr. Lalmingsana and not in the name of Ms. Lalmingsani. Likewise, the name of Ms. Laram Tiama was mentioned in the cancellation order as Laram Liena. Further, he had pointed out the name of Ms. Lalimpui as mentioned in the cancellation order, but no pass was issued in her name. Hence, the Revenue Department had passed the order in casual manner. Amongst 35 persons in whose favor their LSCs were issued by the revenue authorities, only 22 persons were alleged to be within the land claimed by the defendant number 7. LSCs of 22 persons were alleged to be within the land claimed by the defendant number 7 and 8 to 21. Only 10 LSCs under serial number 18 to 25, 30 and 33 were cancelled. Further, the plot of lands for which LSCs were issued in the names of persons shown in para 4 of the plain under serial number 6, 8, 9, 10 are not included in the plot of land claimed by the defendant number 7. There is no complaint in respect of the lands related to Lakatsumi, Erintuanga, Lalimpui, and Linkapa, as the location is entirely opposite side of the land claimed by the defendant number 7. The location of the land of the said persons are not within the land for which illegal LSCs were issued in favor of defendant number 7 and 8 to 21. The Revenue Department was not sure of what they are doing. Rather, they have passed the cancellation order without going to the spot. An order of cancellation passed by the Revenue Department is illegal and without any reason. If the reason given for cancellation is due to overlapping of the land claimed by the defendant number 7 and 8 to 21, the plots of land in the names of Latansumi, Erintuanga, Lalimpui, and Tanlinkapa, which is located outside the land claimed by the said defendant number 7, should not be cancelled. The Revenue Department do not know the location of the LSCs included in the cancellation order. The Revenue Department, instead of helping the landless Mizo villagers, are always helping the rich landlords. They are poor landless Mizos and rich landlords are always exploiting them. The boundary description of the Berdik Pata of the defendant number 7 is not very clear. It only says he was given 8 bigas of land around the person's name in the Berdik Pata. When the revenue authorities demarcated the land in their favor, they left 11 bigas in favor of the defendant number 7, even though the area of land belonging to the said defendant number 7 was only 8 bigas of land. Mr. Tanglian Kapa, son of Hautroma, had transferred the land covered under so-and-so in the name of Mr. Lorenzana, son of Rukuma. The transfer was effected in the body of the LSC on 8/2/2008 by the Assistant Settlement Officer in Laranese Department, but when the cancellation order was issued, the name of Mr. Tanglian Kapa was mentioned instead of the name of Mr. Lorenzana. The defendant number 1 to 6 are not clear of what they are doing at the time of passing such orders. Hence, he had mentioned instead of the name of Mr. Lorenzana. The defendant number 1 to 6 are not clear of what they are doing at the time of passing such orders. Hence, he had mentioned the name of Tanglian Kapa as well as Mr. Lorenzana in the plaint. He exhibited a copy of cancellation order passed by the Director, Land Revenue and Settlement Department, Government of Mizoram 5 Memo number so-and-so, dated 9/3/2012, as Exhibit P1. A copy of order passed by Assistant Director of Survey, Land Revenue Settlement Department, Government Mizoram via the memo number so and so, date 23/11/2004 as Exhibit P2. Copy of letter number 61/2005, sent to the Director, Land Revenue and Settlement Department by Sabil as Exhibit P3. Copy of General Report Statement dated 29/3/2007 of the Lloyd Pool House.
This you can skip.
Madam, I'll go to page 257, madam.
Yes, sir. 257 are all the copies. These are description of the copies. You can come into 258 to cross-examination.
Madam. In his cross-examination, he admitted that LSCs he had exhibited before the court are already cancelled by Revenue Authority, and as per Exhibit P1, cancellation order dated 9/3/2012, their LSCs were cancelled because their LSCs have overlapped Mr. Sabela's land, and they do not challenge the genuineness of the PTA number 159 of 1981. The evidence used by the other three PWs, PW number 2 El Chandama, PW number 3 Lorenza, and PW number 4 are similar with PW number 1 El Duomo. In his cross-examination, PW number 2 El Chandama admitted that LSCs exhibited by PW number 1 before the court are already cancelled by the Revenue Authority, and as per Exhibit P1, Cancellation Order 9/3/2012, their LSCs were cancelled because their LSCs had overlapped Mr. Sabela's land, and they do not challenge the genuineness of the PPTA 159 of 1981. In his cross-examination, PW number 2 Lorenza admitted that LSCs exhibited by PW number 1 before the court are already cancelled by the Revenue Authority, and as per Exhibit P1, Cancellation Order 9/3/2012, their LSCs were cancelled because their LSCs had overlapped Mr. Sabela's land, and they do not challenge the genuineness of PPTA number 6. In his cross-examination, PW number 4, Lalta was stated that he bought the land covered by LSC number 1436 of 2006, issued in the name of Lorin Kluang, who is the plaintiff in this instant case, at rupees 50,000, but he do not remember when did he bought the said land. He came to know that the said land was disputed by the defendants just after he bought the said land. He had never seen PTA of defendant number 7, and he do not know the boundary description of the said periodic pata, and as far as his knowledge, the plaintiff's LSCs were cancelled as it overlapped the defendant's LSCs. He and his family have been settling in their own land located at the Industrial Growth Center, Luang Mall. The defendant number 7 to 21 produced one witness. The Lon D.W. Suanoma submitted his examination in chief, and he stated that he is the defendant number 8 and stand as defendant's witness number 2 in this instant suit. The suit is not maintainable in its present form and style. The plaintiff has no occasion right to file this suit. The suit is bad for non-joiner and misjoiner of the parties, and the plaintiff has no cause of action against defendant number 7 to 21. The defendant number 7 was having landed property covered by periodic pata number 159 of 1981, located at Maubok by describing its location as Maubok Ramsung Chuanchung Ramban Laltangale Benita. It's a major vernacular, which was bounded by the Mingas line in the south, Laltangas line in the north, Langau's line in the east, and Soil Conservation Nursery Farm in the west. The total area of the said land mentioned in the periodic pata was 8 bigas, but it is submitted that there was no proper measurement of the said land at the time of the issuance of the said periodic pata due to non-availability of surveyor in the Revenue Authority, and the area of the land was presumed as 8 bigas vaguely, but the total area as per verification report 79/2004 was 24.30 bigas as per the boundary description. The periodic pata number 159 of 1981 was converted into 25 numbers of house passes in the year 2005, and the same were converted to land settlement certificates in the year 2005 to 2006. The process of the house site plan for the accommodation of MNF returnees was cancelled due to objection made by the defendant number 7, holder of periodic pata number 159 of 1981, and Mr. Chongtan Kuma, holder of periodic pata number 458 of 1980. And as such, house site plan was shifted to Mau Mual, which was clearly mentioned in Para 1 of the General Report, Statement of Lloyd Pool House Site Plan, reported by the Assistant Director of Survey, Land Revenue Settlement, Mizoram, Aizong, on 29/3/2007. The the defendant number 7 was having a valid periodic pata number 159 of 1981 at the time of preparation of house site plan for the landless people of Mizo tribes of Aizawl in the month of August 2004. Demarcation of house site plan for the defendants was done on 17/9/2004, but demarcation of house site plan for the plaintiffs was done on 29/8/2004. Plaintiffs admitted the fact that when the house site plan was prepared, all the plots were located outside the area and boundary description mentioned in the respective patas, and as such it can be presumed that the plaintiffs' LSCs which overlap the defendants' LSCs were illegally issued in contrary to the said house site plan. Hence, cancellation of the plaintiffs' LSCs by the Revenue Authority was blameless and correct in the eye of law. Issuance of house passes to the plaintiffs and conversion of the plaintiffs' house passes into land settlement certificates were done illegally and no legal procedure was not followed. The defendants also have no objection to which the Village Council of Loipu Village had given clearance for allotment of any plots of land if it was not covered by the defendant's land, but clearance given by the said Village Council for the plaintiff's lands which overlapped the defendant's lands was strongly objected as it was beyond their jurisdiction. The defendant number 7 had never received any notice from the Revenue Authority regarding spot verification of house site plan for the plaintiffs, and as per the verification report of conversion of garden under periodic pata number 159 of 1981, date 17/9/2004 was 24.30 bighas. But unfortunately, periodic pata number 159 of 1981 was mistakenly written as periodic pata number 159 of 1983 in the said report. The government of Mizoram had found the truth and cancelled the plaintiff's LSCs. The defendant number 7 had submitted an application for conversion of his periodic pata into house pass to the Revenue Authority in the year 2004, and his land was divided into a number of plots. But the Revenue Authority had told the defendant number 7 to surrender some portion of his land as per the government order, and accordingly, the defendant number 7 had sent a letter dated 6/1/2005 to the Director, Land Revenue and Settlement Aizawl, declaring that a plot for Mr. Monkima, Mr. Lalkama, and Mr. Utuama were surrendered by him and requested to proceed conversion as applied earlier. But conversion was not done immediately, and on 19/8/2004, the defendant number 7 had applied to the Honorable Minister in charge Land Revenue and Settlement Aizawl, Mizoram for conversion of his periodic pata number 159 of 1981 into house pass for his siblings without surrendering some portion of his land. The action of the defendant number 3 is not arbitrary and biased, since the plaintiffs could not prove their title and the government of Mizoram found that they had issued passes to the plaintiffs illegally. The Revenue Authority had made correction decision in cancellation of the plaintiffs' LSCs. The defendant number 1 to 6 had mistakenly allotted lands to the plaintiff by overlapping the defendant's lands, and the plaintiff's LSCs were cancelled when the Revenue Authority had found out the truth. If the plaintiff would like to seek for their right, they have to approach the authority or the court for compensation, not to take possession or title illegally by violating others' rights. Periodic pata of defendant number 7 was issued in the year 1981, and it was converted into house passes in the year 2005, and again converted into LSCs in the year 2005 and 2006, but the plaintiff's house passes were issued in the year 2006 and converted into LSCs in the year by overlapping the defendant's lands illegally. The government never helped the poor by exploiting any person or by violating any law. The boundary description of the periodic pata.
You can come to the issues now.
My lord.
We have more or less understood the cases of the respective parties.
My lord, if I may read the cross-examination portion, my lord.
Yes, please.
At page 261.
261, yes.
At the lower portion, my lord.
Bottom part.
Yes, bottom part.
In his cross-examination.
This is the only witness produced by the private defendants, my lord. In his cross-examination,
Yes.
D.W. Lalshonom agree with the fact that as per Exhibit D2, the PPTA was not renewed between 1991 to 8/5/1993. He does not accept that they received so-called notice from Land Revenue Department 3 times and they failed to reply to the so-called notice. His father is still alive but suffered a stroke and unable to move out of the house. He do not agree with that the land covered by PP number 159 of 1981 was not looked after by them, and he and his family members have no right to interfere with the peaceful possession of the properties allotted in the name of the plaintiffs, including the ones they are representing, and also do not agree with the lands allotted to the plaintiffs were outside the original area of land covered by PP number 159 of 1981. Out of the PP number 159 of 1981, 25 passes were issued to his father and his family members. Though the area covered by PP as shown in the PP was 8 bigas, the total area for which passes were issued covered an area of 24.30 bigas, but paid revenue tax for an area of 8 bigas only. He agreed with that if any mistake is committed in allotting the house site to the plaintiffs overlapping the passes issued them, the responsibility lies on the government and the revenue department. His father, Sab Bela, is still alive but suffered a stroke and unable to move out of the house. The land covered by periodic Pata number 159 of 1981 was not looked after by them. Out of the PP number 159 1881, 25 passes were issued by his father and their family members. Though the area covered by PP as shown in the PP was 8 bigas, the total area for which passes were issued covered are 24.30 bigas. Till the PP was converted into passes, LSCs were paid revenue tax for an area of 8 bigas only. It is a fact that they were not staying within the land originally covered under PP number 159 of 1981. However, they were staying in Maubok area. He is not sure as to whether when his father applied for conversion of PP number 159 1981 into house sites, the area fell within the jurisdiction of Loipu Village Council or not. As his father took steps for converting the said PP into house sites, he personally do not know whether his father knowingly obtained no objection recommendation from Maubok Village Council President instead of Loipu Village Council President when he submitted the application in the year 2004 to 2005. He personally do not know whether his father received Exhibit P2, and he also do not know whether he attended the spot while demarcation was done for allotment of house sites to landless Mizo tribes. He also do not know anything about the portion of land left out for his father while demarcation was done at Loipu village. He also do not know whether his father received Exhibit P4 and P5. However, his father wrote the letter Exhibit P3 to the director, informing him that he had surrendered the plots belonging to Pu Lalbiag Moya Piromiliani, Pu Muankima, Pulalkama, and Puru Truama. It is not a fact that the land allotted to the plaintiffs were outside the original area of the land covered by PP number 195/1981. It is a fact that whatever he knows in connection with this case was derived from his father, meaning that he is not having any personal knowledge. As told by his father only, my lord. He adduced evidence as a hearsay only. It is not a fact that the plots of house sites allotted to plaintiffs were done properly, and he and his family members have no right to interfere with the peaceful possession of the properties allotted in the name of the plaintiffs, including the ones they are presenting. It is a fact that if any mistake is committed in allotting the house sites to the plaintiffs, overlapping the passes issued to them, the responsibility lies on the government and the revenue department. It is not a fact that the statement he had made in the examination chief are not true. Issues and decision. Whether the suit is maintainable in its present form and style. The suit is filed under the provision of Order 7 Rule 1 of the Code of Civil Procedure 908, and the case is at the stage of judgment and order. Therefore, this issue is decided in favor of the plaintiffs and declared that the suit is maintainable in its present form and style. Number 2, whether the plaintiffs have cause of action or not. Since issue number is decided in favor of the plaintiffs, and since the plaintiffs' LSCs were cancelled by the Revenue Authority, this issue is decided in favor of the plaintiffs and declared that the plaintiffs have cause of action. Number 3, whether the LSCs issued in the name of the plaintiffs and the person whom they are representing, so and so, are valid or not. The plaintiffs' LSCs were issued by overlapping the defendant number 7 to 21 LSCs, which were converted as house passes from periodic Pata number 159 of 1981 owned by defendant number 7. Ms. Risabella in the year 2005 and again converted into LSCs in the year 2005 and 2006, and as such the plaintiffs' LSCs were cancelled by the Revenue Authority. The plaintiffs' LSCs could not be declared as valid in the eye of law. This issue is decided against the plaintiffs and declared the LSCs issued to them are not valid. So, my lord, here what can be seen is that there was no such observation made by the trial court also. There was no logical conclusion in connection with the issue, deciding the issue. At number 4 also, whether the defendant's LSCs are valid or not. The defendant's LSCs are made from valid periodic pata number 159 of 1981, and validity of periodic pata number 159 of 1981 is not challenged by the plaintiffs. Therefore, this issue is decided in favor of the defendants and declared that their LSCs are valid. Number 5. Whether the plaintiffs are entitled to the relief claimed, if so, to what extent. Since issue number 3 and 4 are decided in favor of the defendants, plaintiffs are not entitled to the relief claimed. Number 6. Whether the plaintiffs have locus standi to file the instant suit or any cause of action in their favor and against the defendants. The issue number 1 and 2 are decided in favor of the plaintiffs. This issue need not be decided again. Number 7. Whether the plaintiffs can sue in favor of the interested persons mentioned in para number 1 of the plain under order 1 rule 8 of CPC without prior permission of the court. As per order 25/7/2017 passed in CMA number 391 of 2012, arising out of civil suit number 97 of 2012, it is allowed to file representative suit as under order 1 rule 8 CPC 1908, except in respect of Mr. H. Leruyet Puya, son of H. Vanal Zuyan. This issue do not need to decide again. Number 8. Whether the suit is bad for non-joinder of necessary parties. The defendants do not raise any objection regarding the non-joinder of necessary parties. And it appears that necessary parties are fully included in the case, and hence this issue decided in favor of the plaintiffs. Number 9. Whether the suit is liable to be dismissed for want of sufficient court fees. As per order 6/11/2012, court fees at rupees 5,000 is paid, and hence this issue is decided in favor of the plaintiffs. As discussed above, I hereby pass the following order. The cancellation order passed by the defendant number 3 by the memo number so and so, dated Aizol 9 March 2012, is upheld and declared as a valid and standing order. Further, the defendant number 7 and 21 through 21 are declared as legal and rightful owner of the land covered by the LSC issued in their name. With the above orders, the civil suit is disposed. My lord, here what can be seen in the issue decided by the trial court is without any logical observation, my lord, based on evidence adduced by the witnesses. So, in a trial, what the trial court has to see is the evidence adduced by the witnesses in support to establish their stand and the pleadings before the trial court. And in connection with this, the main issue is with regard to the overlapping of the land. Since whether it is overlapped or not, that aspect of the evidence was not available in the evidence also. Even the state respondents did not produce no witness at all. Evidence of the state respondents is not available in the present case. So, in order to rely upon the evidence to decide the question of overlapping, my lord, so there is no reliable evidence adduced by the witnesses. it can be, what can be seen is that the land was verified by, verification was done by one surveyor. And the surveyor stated that it was overlapped. But that person, that surveyor was not produced before the trial court to produce the evidence. So there is a very big question with regard to the question of whether it is overlapped with the land of the defendant number 7 with regard to the land of the plaintiffs or not. So, my lord, initially, even if the area of the periodic Patta 159 of 1981 is written as 8 bigas, that area might need to be correct. But the question with regard to its overlapping or not cannot be decided by the modification in the area, which is increased as from 8 biga to 24 bigas, my lord. Here, the only witness produced by the defendants is Sri Lalchwanoma, my lord. And he didn't mention whether the land of the plaintiffs are overlapped or not. He did not give any evidence in that regard at all. So, the area of the P Patta is also very vague. It is written as 8 bigas. Additional, it was increased to 24 bigas. And moreover, when the defendant, the respondent number 7, applies for conversion of that P Patta into house sites, he obtained the no objection certificate from the authority of Maubok area, which is a different area, my lord. This particular area lies within the area of Loipu. It has, the respondent number 7 has to take the no objection certificate from Loipu Village Council President. Instead of taking the NOC from the Loipu, he had taken the no objection certificate from Maubok only. And my lord, here, during the course of conversion of that periodic Patta into LSC, it was written clearly by the revenue authority that technical sanction was not obtained for conversion of P Patta into house sites. So the trial court also did not make any observation with regard to observation to this effect in this context. Whether will it be still valid without obtaining the technical sanction in the course of conversion of periodic Patta into house site? That aspect was not decided by the trial court also, my lord. And
that was not the issue before the trial court. The issue was regarding your cancellation. It's an administrative action. Cancellation is an administrative action. So we need to know two things: whether there was at all a basis for proceeding with the cancellation. Number two, if there is a basis, whether you have been given adequate opportunity to defend your case before such cancellation. These are basically the 2 points we need to see whether these 2 points were dealt with by the learned trial court. How they got the land pass converted subsequently, this may not be very relevant. See, your allotment process was of the year 2005-2006, correct?
Yes, correct.
And their failure to pay revenue was of which year? 91 to 1993.
That in the evidence.
No, even if you urge that point, that
Yes.
there was a lapse on their part to pay the revenue,
My lord.
which might go to affect their periodic Patta.
My lord.
That was of a much prior stage, 91 to 93. You cannot go back. That is not even the issue. You are challenging the cancellation. That cancellation is bad in law. Why bad in law? Because they did not give us adequate opportunity, number one, maybe, or maybe there was no basis to cancel. These are the 2 points which you can urge and for which you need to reduce evidence. And this is a civil suit. First, you need to discharge your burden that there was no basis to cancel. It is not that the surveyor, the cancellation was based on a surveyor's report and the surveyor was not adduced as a witness. Had it been a criminal case, matter would have been different. You are proceeding on a presumption, on a basis, without the person being examined as in the dock. This is a civil suit. First, you have to discharge your burden. Then only the onus will shift on the defendants. You have to stand on your own legs. That I was not given adequate opportunity to defend my case. The cancellation was done without even giving me a notice, without even hearing me. That is not your case. So to challenge an administrative action, the scope is very limited. By meaning, it will not mean that you do not have a scope. You have a scope, but scope is on the specific grounds. That I was not given a proper hearing, violation of the principles of natural justice. That is not seen. And so far as assailing the basis is concerned, that is a very weak kind of a footing. If you say that the surveyor's report was not correct, that is what you want to project, then the burden is upon you, entirely upon you. The civil suit, you are the plaintiff, you have to stand on your own legs. The judgment may not be very happily worded because while coming to the issues and decisions thereof, the discussions is not adequate. That's a different matter. But he has shifted through the evidence on record elaborately prior to coming of the issues. It's a slightly different manner. Normally the issues needs to be framed first, then you discuss the evidence, then you answer the issues. Here the answer to the issues are slightly in a very brief manner. That's a different aspect, different aspect. But we cannot read this page 263 and 64 in isolation. We have to read with the earlier discussion of the evidence. Is it your case that you are not given proper notice or deprived from contesting the step to cancel?
My Lord, here in the with regard to the procedure of passing the cancellation order, I had also stated in my grounds of appeal that procedure lacks the principle of natural justice, my Lord.
Yes, procedure, there was lapse.
That procedure, yes. What I have mentioned is that, my Lord, here in the ground number 13 of my
Yes, you
appeal,
can
my Lord.
elaborate. You can please elaborate. What have you stated?
My Lord, in the course of passing the cancellation order,
Yes.
that cancellation order on 3rd January 2012, the proposal letter was sent to the Principal Secretary to the Government Mizoram Revenue Department by the Director, suggesting the concerned government authority to cancel the LSCs of the plaintiffs, my Lord, and saying that the same overlapped the land of the defendant number 7. And that is on January 3, my Lord. And on January 24, the government sent approval letter to the director and for cancellation of the LSCs of the plaintiffs. And only after making a decision, my Lord, decision was made already. And only after the decision was made, so-called notice was served to me on 6th February only. Belatedly served to the plaintiffs. After approval,
What is the date of the notice?
the date of the so-called notice was 6 February 2012.
And you said the approval was when? 24th of January
Yes, my lord, 24th of January.
2012. Approval to cancel.
No, my lord. Approval was given
To cancel.
to cancel.
And when was it sent by the directorate? 3rd, 9th,
3rd January
3rd January. What directorate has
2012 by the director.
sent to the state government?
Yes, my
Seeking
lord.
seeking approval.
Approval of the state government to the principal secretary. So here it can be seen that all the decisions were made.
Let us see these three documents, 3-1, 24-1 and 6-2.
But page 25, my lord. Page 25 of the paper book.
Okay.
And page 27 is the approval given by the,
Please read 3-1. This
page 25.
Yes.
Page 25 is the
Please read.
letter of the director sent to principal
No, no, sir,
secretary
yeah,
seeking approval for cancellation.
Land dispute.
May I read, my lord?
Just a minute. Please read.
Ma'am. To the Principal Secretary to the Government Mizoram Revenue Department, subject land dispute at Loi Puveng. Sir, with reference to your letter on the subject cited above, I have the honor to submit herewith our findings in connection with land dispute at Loi Pu for favor of your kind information. That Pusa Bela was allotted plot of land under periodic Pata number 159 of 1981 with an area of 8 bigas as per his Pata at Loi Puveng, with the following boundaries as under south, Minga, north, Malaltanga, east, Tlangau. It appears that Tlangau should be as Tong, west, soil conservation nursery. But when the land was redemarcated for conversion of house paths, the exact area of the Pipata as per the boundary description is 24.30 bigas. Accordingly, as per the approval of government, 25 house paths was issued to Pusa Bel and his families. However, the boundaries mentioned in the Pipata does not encroach the redemarcation by the approval of government, which is enclosed for reference. At the same time, the Village Council of Loi Pu Department, which prepared house site plan with the area of Pipata number 159 of 1981 in respect of Pusa Bela, were allotted to 15 persons, widely enclosed. As per complaint made by Pusa Bela, Pudong Kima, the then Assistant Director of Survey, and Pu Evel Machuana, surveyor, carried out on the spot verification of the land dispute, vide their report enclosed for ready reference. Moreover, this directorate instructed the Assistant Settlement Officer 1, Aizol, to uphold the house pass issued to Pusa Bela and his family's vide copy enclosed. However, the President Village Council Loi Pu submitted representation stating that the area of Pipata covered 8 bigas only and the remained area be house pass issued to Pusa Bela and his families be cancelled.
Okay, we have read. We have read this.
Malo.
And ultimately, this so-called notice was given to you on 6/2/2012.
My lord.
After the approval was
My
already
lord.
given by the
All
state
approval
government.
were all given already, my lord. The so-called notice is at page 28, my lord.
Yes, we have seen that.
My lord. So here I have submitted that there is that procedure in the course of cancellation lacks the principle of natural justice, as direction was already made before serving show cause notice to us. So,
But will it make a substantial change in the decision-making process?
my lord, in the regard, by looking at the evidence available on record, my lord, there was no substantial evidence which may show that there was an overlapping with regard to the lands of the plaintiffs as well as with that of the land of the defendant number 7. There was no evidence at all, my lord. That only one witness was produced before the trial court, Sri Lal Chuanoma, and that particular witness also did not mention about the situation with regard to the overlapping of with regard to the exact situation as to how it was overlapped, or even if it is overlapped, as to how it is overlapped, that aspect of the evidence was not available in the case record, my lord.
Okay, tell us one more aspect. What kind of vested right what kind of right was vested upon you? Did you have any vested right upon over the land which was sought to be allotted to you?
My lord, here,
You were a beneficiary of a process. It was not the thing that you had purchased it or there was a sale deed or transfer deed. It was an allotment, a settlement by the state to landless people.
my lord.
And while doing so, the state realized that it was already over a periodic patta land of particular individuals, and therefore it was cancelled. Now, can you question into that part if you are not raising the aspect of bona fide or mala fide?
My lord, in that regard, what is to be seen is that, my lord, some particular portion of the periodic patta may be overlapped, but not all of the pass issued in favor of the plaintiffs did not overlap the land of the respondent number 7. That aspect is to be clarified by the trial court. But there was no such observation or clarification based on evidence, my lord, adduced by the witnesses. So what can be seen from the evidence is that some of the landowners' land, the lands outside issued to some landowners did not fall within the area of the periodic patta also. So that aspect is required to be clarified, my lord. So, but that particular aspect is not clearly decided by the trial court also. We did not deny that some portion of that particular area of the periodic patta might be overlapped, but not all of the land of the periodic patta is not overlapped by the lands issued to the plaintiffs, my lord. So, the trial court may.
Now, what is the status of the land?
The status of the land is as not.
Are you in possession?
That is not cultivated, my lord.
Now, are you in possession?
True of the land, plaintiff number 1 and 2 are already constructing houses. I'm still living in that house.
You are in possession of that land.
My lord, yes. I'm still in possession of that particular land. I have no other plot of land.
Anything else?
And my lord, here, what can be seen is that the concerned department of the Revenue Authority also stated that the lands issued to the plaintiffs was issued after observing all the caudal formalities, my lord. Observing all the caudal formalities, there was no illegality in the course of conversion of that house pass into LSCs. So as per the land law prevailing in the state, my lord. LSC holder shall have the transferable and heritable right. There is a permanent ownership. If a more appropriate and specific clarification is made by the trial court with regard to the question of overlapping. Overlapping is the main issue, my lord. Then if my land overlapped the land of the respondent number 7, with a more appropriate verification or with a more established evidence on record, then I would not challenge the order of the trial court, my lord. But in this regard, there was no such observation. All the lands issued the plaintiffs did not at all overlap the land of the defendant number 7. Here, in order to say that by name, my lord, Srimati Tanchungi, Sri Lorin Tluanga, Srimati Dinpui, and Sri Thang Lien Kappa are not included in the plot of land claimed by the plaintiff, the respondent number 7 also. These 4 persons, landowners, are also cancelled, but they are not, their land is not within the land of the, clearly not located within the land of the respondent number 7 also. So there are some complications in that regard. So supposing if the trial court formed the verification team, then clarification can be very well made by my lord. If there is a team to study and verify that situation, then the court can very well decide in favor of all the stakeholders.
Did you pray for any commission
During the,
trial court?
no, my lord.
Then you could have prayed for a commission if you at all you think that the process of cancellation, allotment, where there were ambiguities for clarification, you did not pray for any commission.
And also, my lord, one of my submission is that with regard to conducting final hearing, my lord, there was no final hearing conducted by the trial court. And here, what I'd like to state is that when the case was fixed for final hearing on 10/12/2021, it was the judgment and order was not pronounced on that particular date. It was fixed, it was pronounced on 14/12 instead of 10/12, my lord. The reason was not reflected and there was no adjournment in the case record also, my lord. So it was pronounced behind the back of the plaintiffs and the lower court is silent about the reason of not pronouncing that judgment and order.
Where is the order sheet? Page? You said it was fixed on 10.
Fixed on 10/12, my lord.
Yes. From where are you making this submission? Order sheet?
My lord, in that regard, I'm not enclosing the supporting documents, my lord. That might be available from the lower court record also, my lord, if the LCR is available, my lord.
The hearing was concluded. 112 order sheet says, counsel for the plaintiff are present, hearing is conducted. Fix 10-12-21 for judgment and order.
My lord.
10-12, there is nothing.
And on that 10-12, judgment. Judgment was not pronounced. It was pronounced on 14-12, my lord. And my lord, if I may continue, my lord.
Just a minute, please. Yes, what is it?
My lord, with regard to the written statement submitted by the private defendants, that is available at page 171 of the paper book.
171.
171, my lord. 171, and in the prayer portion, in the prayer portion is at page 181. 181. In the above facts and circumstances aforementioned, the applicants, defendants praise this honorable court allow this application. This is a written statement. He should have prayed for dismissal of the suit, but he only prays to allow the application. So what is the prayer? This is very vague also. But in the meantime, instead of whether allowing the application or not is not known, but the impugn order had declared the respondents to be the rightful owner. That is the relief is granted beyond pleadings, my lord. With a very vague pleadings, the lower court had granted relief to the respondents by declaring the respondents as the rightful owner. It had declared. They did not plead for that, my lord. That is beyond the pleadings. So
There was no counterclaim.
No counterclaim at all. There was no counterclaim. That aspect of the impugned judgment order is bad in law, and it is also liable to be quashed, my lord, and set aside. And my lord, in connection with my submission, I'd like to rely upon the authority of the Honorable Supreme Court.
Which one?
This is, my lord, decided in 2005, S5 SEC, page 784, United India Assurance Company Limited and versus Samir Chandra Chowdhury, which is at
Paragraph?
paragraph 11, my lord, paragraph 11. Last page, my lord.
Yes.
Last page, if I may read.
Yes, please.
I'm highlighting the portion that
Yes.
admission is the best piece of evidence against the persons making admission, as was observed by this court in Avad Kishore Das versus Ram Gopal in the backdrop of Section 31 of the Indian Evidence Act 1872, short the Evidence Act. It is true that evidentiary admissions are not conclusive proof of the facts admitted and may be explained or shown to be wrong, but they do raise an estoppel and shift the burden of proof, placing it on the persons making the admission or his representative in interest. Unless shown or explained to be wrong, they are inefficacious proof of the facts admitted. As observed by Philip Phipson in his Law of Evidence, 1963 edition, para 678, as the weight of an admission depends on the circumstances under which it was made, these circumstances may always be proved to impeach or enhance its credibility. The effect of admission is that it shifts the onus onto the person admitting the fact on the principle that what a party himself admits to be true may reasonably be presumed to be so. And until the presumption is rebutted, the fact admitted must be taken to be established. An admission is the best evidence that an opposing party can rely upon, and though not conclusive, is decisive of the matter unless successfully withdrawn or proved erroneous. My lord, here there was what I'd like to add in support of this decision is the evidence of the DW, my lord. There was an admission on his part that the area covered by the periodic pata is only 8 bighas. In the periodic pata itself also it is written as 8 bighas. He admitted that.
Yes.
And after the area was increasing the area caused the present dispute, my lord. And the said DW also admitted that whatever he knows in connection with this case was derived from his father only. He did not have any personal knowledge at all. Only what was told by his father only. It's only a hearsay, my lord. That is the only witness produced by the respondents, my lord, also. So this piece of evidence cannot be made to decide the present case in order to arrive at an appropriate justice, my lord, the appropriate decision. And also stated that the PPTA, he admitted also that the PPTA was not renewed between 91 to 93, which may infer that there is irregularity in the course of maintaining the periodic pata, because the periodic pata is deemed to be expired upon the non-payment of revenue
You
tax.
said it is 5 years. Here the period, if we assume that to be correct, is 3 years. And it is much prior to the present process of allotment. That was the question which you have put. Present process is of when? 2004-5, 5-6. That was of 92-93.
My lord. And what I'd like to mention is with regard to that area, that was 8 biga. And with regard to the admission that what he know is derived from his father only, my lord. And also with regard to, my lord, the decision made in 1997, 11 SCC 460, my lord. 1997, 11 SCC 460.
Yes. Paragraph?
Paragraph 2, my lord. If I may read, my lord.
Please.
We have heard the learned counsels for the appellant as well as the learned additional solicitor general for the respondents. We find from the facts laid on record that the appellant had preferred a claim of rupees 15 lakhs on account of the death of his daughter, Sabah, on 24/12/1986, when she was about 4 months old. The mother of the girl, a resident of Bhopal, was one of the victims of the gas tragedy, and the case.
What is the point you're trying to drive? These are the facts.
My lord, with regard to the non-availability of evidence, my lord.
What has been stated as a point of law?
My lord, here, the evidence could not have been, it was not supported by any research in connection with the decision made in this case, in connection with this case.
You have made your point. This may not help you. This may not be relevant. You said that there were no adequate evidence.
My lord, yes. In this context also, in this aspect, in this decision also, there was no adequate research to arrive at a reasonable decision, my lord.
This decision may not help you because this is more on speculation. Whether as a result of the Bhopal gas leak, the infirmity was there with the child
My lord,
on that
yes.
aspect. But you have made your point that in your case, there was inadequate evidence
Yes, yes. Yeah, that is,
to come to a conclusion that there was a basis for going ahead with the cancellation. That is your point.
my lord, yes. That is my point.
Okay. Yes, madam. Yeah, for the state.
Yes, I'm appearing for the state lordship. With regards to the cancellation lordship, I'd like to read out my written statement filed on behalf of the state respondents in the trial court. That is on page 150 of the paper book.
150.
150. The relevant portion is on page 151, 151.
Yes, please.
Para number 10. That with regard to the statement made in para 3 of the plaint, it is submitted that due to misrepresentation of the fact of the case and due to absence of the periodic pata holders, while the land was earmarked for allotment to the landless outside plan was prepared outside the area and boundary of the periodic pata number 159/198 of defendant number 7, para number 12, Lordship, that with regard to the statement made in para 8 of the plaint, it is submitted that defendant number 7 has approached the revenue department for conversion of the land covered under periodic pata to outside. Conversion was done with approval of the government as per Honorable High Court's ruling WPC number so and so, wherein the High Court Honorable Court has decreed that if the area given does not tally and the boundaries cover a larger area than what is shown in the certificate, the entire area included within the boundaries must be considered to have been sold. Hence, the department has no other alternative except to cancel the LSC of the plaintiff. Para number 13. That the statement made in para number 9 and 10 of the plaint are wrong and denied. It is submitted that show cause notice was served to the defendant number 7 on 10/10/2007. The proposal was submitted to the government on 3/1/2012. The approval of the government for cancellation of 15 LSCs issued overlapping and the demarcated area of defendant number 7 was conveyed on 24/1/2012. That show cause notice was again served to the plaintiff on 6/2/2012. That only after show cause notice was served to the plaintiff, cancellation order was issued on 9/3/2012. This was all annexed, Lordship, in the written statement. And Lordship, para number 14.
Since we are in paragraph number 3,
Yes,
he's trying to make a very specific point
yes,
that prior to even issuing the so-called notice,
yes, yes,
you
yes,
had taken a decision,
yes.
not only taken a decision, approval also given.
yes,
So the entire exercise
yeah.
of purporting to give an opportunity becomes very mechanical. So how do you overcome this?
Lordship, Lordship, that I have a limited knowledge in that regard, but however, it can, in my humble opinion, I believe the state respondents at this stage, at that time, was have failed to provide a show cause notice, and however, they had.
Don't you think that it is a kind of a post facto decision? You have already taken a decision.
But however, Lordship, they have sent a show cause notice to the plaintiff. So there's no procedural lapse or there's no violation of principles of natural justice.
No. That's the thing. What is the essence of principles of natural justice? Before you take any adverse action against a particular individual, take his views, hear him, give him an opportunity. Now you detect some illegality. You should normally, ideally, you take his views, then you take a decision. Here it appears that you have already decided to cancel. And not only decided, you had gone to the extent of taking the approval from the government. Thereafter, the approval was not for the purpose of giving him a show cause. Approval was for the purpose of cancellation. If the approval was that we have detected this, we want to proceed with the matter, kindly give us approval. Yes, approve. Give show cause. Take his views, take a decision. But still then,
But still,
all,
then,
all,
Lordship,
all
yes,
said
yes.
and done, I had put a question to the learned counsel. That
So
will
was
it make a substantial difference? Now, this is a scope which you have. Whether a so-called notice was given even prior to taking the decision would have made any difference to the decision-making process. The response from the plaintiff side, appellant side, was that the only witness is a defendant.
Yes.
DW
One lone defendant was there. Yes.
DW7, and who himself states that the area in question was not 24. Area in question was only 8 bigha. And if 8 bigha was the area, the dispute would not have arisen at all. Now the dispute has arisen because the area has expanded. We have tried to bring in this part at paragraph 12.
Yes.
That
Paragraph
High
12. This there is
High
a
Court- High Court decision.
Yes. Moreover, this lordship, the apex court decision is also there. This is well principles, legal principle. This is also passed by the apex court, lordship. But I do not have a I do not have a ruling today, lordship. But however, I have a citation in this regard regarding that the boundaries shall prevail when there is a dispute between the area and the boundary. 2006 volume 5 SCC 466 Subaga and others versus Soba and others.
Suba?
Subaga SUBHAGA and others
SUBAHA?
GA and
Subaga.
others. Yes. And others versus Soba and others.
SOBA?
Yes.
SO?
SHOBHA.
SHOBHA. Shobha.
Yes.
This is from which state?
Lordship,
Okay, doesn't matter.
I do not have a printout, Lordship. I have some technical difficulty in the morning. I don't have a printout in this. There's a well principles, settled principles in this regard that if there's any dispute between the area and the boundaries shall prevail. So there's moreover, Lordship, there's a
In case of dispute
between the area and the boundary description shall prevail. And Lordship, if Lordship can come I'll just read out this para number 14 again, Lordship. Even the government are trying to make an alternative arrangement with regards to the plaintiff land. This was in para number 14.
Yes.
That with regard to the statement made in para 11 to 13 of the plaint, it is submitted that reliable officers and staff has carried out on-the-spot verification of the suit land, and on the basis of the verification report, proposal was made to the government. It is submitted that the court may consider location transfer in favor of the plaintiff, where reservation is made by the department, since the suit land was allotted to the plaintiff after observing all cordial informalities prescribed by the government, Lordship. Even though the LSCs were cancelled, Lordship, even the state government has...
Where are you reading?
Para number 14 of the written statement, that is on page 152.
Yes, please read again.
And the top,
It is submitted that the reliable officer and staff had carried out the on-the-spot verification and on this.
court may consider location transfer in favor of the plaintiff, Lordship.
Okay.
And what I like to add is that, Lordship, the state
No,
government...
the same submission, Learned Council is also making that the allotment which were made in their favor
Yes.
was also done by following the
Yes.
codal formalities.
Yes, that's why even the state government is try to make some arrangement, try to the location transfer in favor of the plaintiff also, Lordship, as per the written statement.
Is
And
it?
Lordship,
Have you given some other location to the plaintiff?
Lordship, there are other. Okay, Lordship, if your Lordship can come to page number 21 of the paper book. This is the
21.
21, yes. This is the general report statement of Loipu House site plan.
Yes,
It's a short one, Lordship. I'll read it out.
21.
Yes, page number 21.
Yes.
Due to complaint made by Sri H. Sabbel and Sri C. Tsongthangkuma, report is made by the government in this behalf regarding Loipu House site plan. This report is made to solve the dispute easily by the concerned authority. The MNF returnee had 234 numbers of house site plan plot surveyed in the year 1989 at Loipu near the land allotted to soil department. In this site, Sri H. Sabbela, periodic, but this is defendant number 7.
Yes.
Periodic pata number so and Sri C. Zongtangkuma, periodic pata so and so had a plot of land, and therefore they made a request to exclude their land from the plan. As such, the house site plan was not processed. Therefore, house site plan was made at Mau Mall in favor of the returnees. These returnees, our lordship, are the plaintiff. So there is an alternate location
No,
for
they
the
are
house
not
site
the,
plan.
they are not the plaintiff. Plaintiff says that they are not nothing
They
to
are
do
the
with.
plaintiff.
Plaintiff says that they are nothing to
No,
do with
no.
MNF return. They are.
Your lordship is correct, my lord.
They
You
They are
said
not
that
the plaintiff.
you are landless.
they are landless, yes.
Yes,
No,
yes,
you
correct.
said at the initial, when you opened your arguments, decision was for giving land to the MNF returnees.
Yes,
Then something was found wrong, then the entire location was changed.
Yes.
Yes,
The
Then,
Mau
then
Mall,
still
yes.
some land was found in the same location.
Correct.
And therefore, certain landless people were tried to be given allotment, which included you.
My lord,
That
yes.
is your
that
submission.
is correct.
They are not MNF returnees.
Lordship, I apologize for that. I was not a counsel in the lower court, so that's why. This, moreover, Lordship, what I'm trying to submit here is that the counsel for the appellant has stated that there is no evidence or no material that there is no base for cancellation of their LSC.
Correct.
But I think it's very clear from this document that their land can be cancelled by only this also, page number 21, Lordship,
This
this
21,
document.
20
This is the statement, this is the general report.
21 was proved.
Yes, Lordship, this is exhibited in the court, exhibit P4.
P4,
Yes.
okay, okay.
And moreover, Lordship, even the state government has already admitted that they have made a mistake in the written statement also. It is very clear that they have made a mistake and have allotted, have encroached upon the land of the defendant number 7. And regarding the overlapping of the land, also in this statement made in this page number 21, it's written there, Lordship, para number 4 also, there's an overlapping in the defendant number 7's land. Para number 7 also, I think it's very clear from the, if you read it out, Lordship.
Page?
22, para number 7.
Please read.
After careful survey in allotment, Sri Tsong Thangkuma and Sri H. Sabbela made a complaint again. Pool and Mankima surveyor investigated Sri H. Sabbela's land and reported that his periodic pata, which was converted to house site plot number 1 to 16 and house site plan plot number 14 to 35, is overlapped. Soon, Sri S. Sabbela conversion process was checked, and it was found out that Sri P. Zatluanga, surveyor, revenue district office, measured Sri H. Sabbela periodic patta, which is 8 bigas to 24 bigas. This was already read out by the counsel for the appellant also. Other than 8 biga of the periodic patta, the remaining 16.30 bigas is in contradiction with Department Office Circular so-and-so .22, as it was processed without taking technical clearance and was signed by Maubok VCP without acknowledgement of Loipu VC, and therefore it result in overlapping. This was, Lordship, this document was exhibited in the trial court, so that's why there is a material available on reports that even the trial court, the learned trial court has also come to a decision that the LSC can be cancelled within, that there is an overlapping and that the LSC can be cancelled, and moreover, the cancellation order issued by the government was clearly upheld, was rightly upheld by the learned trial court, Lordship. And in my humble opinion, Lordship, there is no infirmity made by the learned trial court And moreover, Lordship, even the counsel for the, even the appellants have not made any prayer to the, in the trial court, in their plaint, that the LSC nor the periodic pattas were never challenged in the trial court. So the periodic patta also stands and the LSC also stands.
What was also argued
Yes,
that in absence of any counterclaim,
yes.
how could there be a declaration in favor of the defendant be made regarding the validity of the LSC?
That was one of the issues framed, Lordship, in issues number 4, whether the defendant's LSCs are valid or not. It was clearly framed in the issue. So maybe there's no counterclaim, but I think based on these issues alone, it can be held valid.
Which issue?
Issue number 4, whether the defendant's LSC are valid or not. It is on page 264.
Yes. 260?
264. Para number 2, there's issue number 4, whether the defendant's LSC are valid or not.
Okay. Those were the private respondents? No, let her complete. Have you completed?
Lordship, yes, what I'd like to submit is that the Land Trial Court has rightly upheld the cancellation order passed by the state government.
How long will you take? It's lunchtime, so
I won't take long. Since I have adopted like the government advocate submissions,
1:15 meeting there. Huh? Oh. We'll have to continue later. We have a meeting at 1:15. So
yes.
if you can complete, how long will you take?
I won't take much time because most of my submissions are already adopted from the government advocate as like she submitted
Here for the respond number?
respondent number 7 to 25. Respondent number 7 to 21.
7 to 21. Yes.
Yes, would like to submit that the defendant periodic patta was never challenged by the plaintiff, and it was legally issued by the state defendant, and also no infirmity was made by the lower trial court, and the defendant LSC stands valid.
Yes.
And that's all my submissions. That's it.
You're very confident that you have a very good case. So no submission is required. Okay, we conclude this. We'll decide. Okay. What about the other case?
My lord, if it may be, take up in the next week, my lord.
MSc matter.
Yes, my lord. But the other councils are.
You are for the other side.
are here.
Yes, when do you want? As on a joint request made on behalf of the parties. List in the next week.
My lord.
Well, don't say Friday, but can we have it on Thursday or what?
That may be possible, my lord. That-
Or Tuesday?
Tuesday.
Tuesday. On Tuesday. Yes.